Yes, Council, it's nice to have you on the show, Man and Markets. You're most welcome. From where you sit and according to what we are seeing right now, what's your prediction? How are the number of cases going to increase? And this will be affecting the economy. The courts, of course, incur a lot of money to pursue.
I hate to be the prophet of doom, but I do also mediate matters at the commercial court. And so I know the kind of business disputes or commercial disputes that are already starting to come through. So if you look at the whole perspective, the economy, who comes to the commercial court? So you have like banks who already we have a lot of distress on facilities, loan facilities. We have supply chain disruptions. You have trade disputes. You saw during the time of the lockdown, a lot of goods were stuck at the border.
Yeah.
Because of the measures that were given by government.
Yes.
So you have a lot of supply chain disruptions that happened. You have, in terms of construction, okay, we have a lot of construction disruption that occurred because of the lockdown. So if I'm to predict that if people do not become aware and start dealing with these issues without a general blanket of, okay, let us go to court, it would be a doom. I mean, we're already feeling the loom, but it will move to doom because we'll find that a lot of matters would be taken to court, and of course, rightfully so. It's not that it's wrong to go to court, but strategically as a business, you have to ask yourself: does it add value for me to go to court if I have another alternative way that I can get the same result? So you explore those. In as much as you're conflicting, your interest is to, one, be paid if you are the supplier, or two, find a way you can mitigate the loss that you had as the receiver. Okay? So otherwise, what happens is when all these matters go to court, there will not be exchange. There won't be exchange for value, exchange of resources. Everything will be stuck until the court rules on what kind of disruption, who was wrong, was it a miscommunication, was it in terms of, contract performance, what went wrong, and that will take time. So you find that all this money that could have been paid out if people had resolved issues arising from COVID in an alternative way will now be stuck in court. And remember, what this money is stuck in court, it accumulates interest.
True.
It accumulates interest, value for money is lost. So you find where you had a contract where you are supposed to pay about 10 million and your matter is resolved in the next 3 to 5 years, which is the timing now that you take to actually litigate a commercial dispute. The value of 10 million is gone. You are paying more than you were supposed to have paid in terms of interest, in terms of costs. So I think businesses have to realign and rethink. And transaction advisors, whether they're lawyers, whether they're financiers, whoever is in that business, however small it is, it's time now to sit and think strategically. What other options do we have? And have interest-based negotiations. I mean, it's no longer a matter of who's right or who's wrong. We are way past that. COVID happened and no one can pinpoint. So now it's for us to get together as a country, as businesses, as individuals, to rethink our strategies. Going to court, having a win or lose approach, having a litigious approach, is that the best approach to this? And once you answer that question, then I think our economy will start seeing prospects of us realigning ourselves back to getting to where things were.
Maybe because our viewers there would love to know more about this arbitration issue. Just stress it a little more.
Okay.
Yes.
So when you talk about alternative dispute resolution, these are alternative methods to the traditional court, if I can say. Alternative dispute resolution has been there for as long as time. If you remember, we all know traditionally as Ugandans or any African society, every time you had an issue, there would always be that person. Either you go to the community or you go to a leader or whoever it is and you bring your matter before them and they, you discuss it until you find a solution, and once you find it, you go with it. And things were simple. Until, we got into British colonialism, things started becoming more processed, more structured, no cases have to go to court, and that's what started becoming the mainstream kind of dispute resolution. But now we refer to it as alternative. It is recognized by law. There is a law, Arbitration and Conciliation Act in Uganda, and under it we have many mechanisms. Things like negotiation. When you have a dispute, you can get an expert, a neutral third party. They come, negotiate your dispute.
Yeah.
It's you have mediation, you have arbitration, you have conciliation, you have an expert evaluation. There are so many methods. So it's up to the parties and their advisors to, examine that dispute and see which mechanism will work best for us. And of course, the advantages of it, like I said, it's interest-based. What is our interest? As a business, for example, I'm a law firm, I have no interest of being taken to court all the time. I might go to court, but I don't have money to put in saving myself from any judgments that will be given. So it's interest-based negotiation. Like I said, landlords, tenants, any other disruption that has happened in business, what is our interest? My interest is to get paid. My interest is to have my goods delivered.
Yes.
COVID occurred. We cannot pinpoint who was the cause. How do we get back to the table? The other thing, it's very cost effective. You determine how much. From the word go, I'll tell you, this is how much I'll charge to mediate your matter or arbitrate your matter, and it's known and it's a shared cost, so there's that engagement. You go to court, of course, you file your fees and what, but because of the time that it takes, you never know how much at the end of the day that your lawyer will charge you, because there's no control of time. With alternative dispute methods, you have control of time. You can agree that within 2 weeks, 3 weeks, our matter should be resolved, and you work within that time. There is the issue of confidentiality. I mean, for any mediation or any ADR to happen, the principle is based on confidentiality. I mean, you've seen what happens in our court cases. Once you file your case, it's in the public domain. A matter that started, remember, any contract starts as a private relationship. You come here, you offer to, provide me media services, we are in a very good relationship, we sign our contract. No one knows. But when miscommunication, any miss that happens, like COVID, that's a miss. No one predicted it. We end up going to court, for judgment on a matter we started privately. So you see, something doesn't add up. Of course, there are exceptions, like fraud. If there is fraud, you need to seek for judicial remedy. Fraud in a contract, if it's a contract that was against public interest, there are those exceptions. But ideally, as a principle, any matter that was started privately should not be taken out to the public.
Thank you so much.
You're welcome.